Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Paige Kilbane, Judge, presiding. All persons having business before this court draw near, give attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning, everybody.
Good morning.
I am Judge Paige Kilbane, and to my right, we have Judge Harvey J., and to my left, we have Judge Jordan Pratt. And welcome to a very special session of the 5th District Court of Appeal. We are sitting today in Clay County, which is one of the 14 counties that encompasses the 5th District. So thank you all for coming today. We also are celebrating Law Day today, which is technically celebrated on May 1st, but very often celebrated in the weeks surrounding it. So we have lots of students here today. The purpose of Law Day was started by President Eisenhower, and essentially it's to educate the public about their personal rights and liberties that we enjoy here in the United States. So I hope that we'll learn something today. After the session, we're going to have a Q&A with the students, with lawyers, with us, whoever would like to stay. We look forward to doing that today. We also have with us today, as I mentioned, we have students, but we have students from several different places. So we have Clay High School's Public Safety Academy, and that encompasses students 9th through 12th grade. I'd love to hear more about that later. That sounds very interesting. And we also have their teachers, Daniel Harris and Denzel Davis. So thank you so much for being here. We have students from the Clay County Teen Court Program, and its leaders, Michelle Taylor and Stacy Smith. So thank you all so much. We also have Clay County School District. From the school district, we have Mary Owen, Stephanie Mavaro, and Rachel Holmgren, and they are responsible for the civics curriculum. So I'm sure they know a lot more about Law Day than I do, and they may want to share that with us later too. So with that, we will go ahead and get started with our first case. So just to give everybody sort of a rundown of how this is going to go today, we have technically 3 cases set. The first 2 cases are what they call traveling together. So they're from the same case, but they have some different issues. So we're going to have the same lawyers for those 2 arguments, but it kind of is derived from the same case. So what we'll do for those, and I'm not sure if you all are aware, we're going to sort of have them back to back, but have them argued a little bit separately since they are different issues. So it'll be 30 minutes per case. And then, so the first one we'll do is Brosnan versus State Farm. And then we'll do the second one. So how much time for rebuttal on that knowing we'll have 15 minutes?
15 minutes total?
Yes.
Just 5 minutes.
5 minutes for rebuttal?
Thank you.
Okay. And you can go ahead and reserve.
4 minutes for rebuttal for the fee appeal.
Okay. Wonderful.
Thank you very much.
All right. So with that, the first case we're going to call is case number 22-3062, and that is Glenn Brosnan versus State Farm, Florida Insurance Company, and Lucille V. Brosnan.
Good morning, Your Honors.
Good morning.
Mark Nation on behalf of the appellant in this case. And for the benefit of our guests, I'll give a little bit of background of the case, what it's about, and then get into the argument. Mr. Brosnan was insured by State Farm as a homeowner's insurance company and submitted a claim for water damage to his home. State Farm investigated the claim and found that there was coverage for that water damage and allowed for payment to be made. We argued that it was not enough and filed a lawsuit against State Farm in order to have a jury determine the appropriate amount owed under the policy. And so it progressed and went to trial. At trial, I put on evidence from Mr. Brosnan and some experts, but an issue came up about Mr. Brosnan's sister. His sister had been down for Thanksgiving around that time, and it's unclear, and we'll get into why, what she saw, what she had to say, as far as the jury was concerned. During my case, I had contemplated reading her deposition. She lives in New York, and because she's a fact witness under our rules, either side would be allowed to read her deposition to the jury. Either side could do that, equally available to either side. During my case, we decided, after some back and forth, not to read her deposition during our case. But during our case, counsel for State Farm, I think 4 times, said they were going to read her deposition during the case. 4 times. And in fact, they asked if I was going to try to prevent them, and I made it clear I couldn't stop them if I wanted to because of our rules allowing an unavailable witness's deposition to do that. They said they were going to read it. I finished my case. They put on their case. In their case, they chose not to read that deposition, which was their choice. They had the right to do that. And that's not what our complaint is about. As soon as they decided not to read that deposition, I asked the trial court judge to issue an order preventing them, in closing statements, from mentioning the sister or mentioning that we had not called the sister. Counsel for State Farm said that he should be allowed to do that, either directly or indirectly, or later he said obliquely. The grounds for me making that motion was neither party can comment upon the absence of a witness if that witness is equally available to both sides. Clearly, this deposition was equally.
Mr. Nation, just so we all understand, as I read the record, your client gets on the stand and testifies, and on cross-examination for the first time in the case, is alerted to the fact that the date he thought this event happened on was Thanksgiving. So he then changes the date during cross-examination. Given that event, mid-trial, in real time, why would it not be appropriate for State Farm's attorney to talk about the lack of evidence as to that date? Why did that not bring it into play by virtue of your client's testimony?
They absolutely can talk about the lack of evidence. What they cannot do is ask for a negative inference or inference or comment upon the absence of the sister. Because what that does is calls into speculation what she would have said. There's no evidence of what she would have said in this case. And so there's no exception to that rule.
And thank you, Ms. Nation, you did an excellent job elucidating that in your briefing. But I wonder if the difference here, perhaps, I'd like to hear what you have to say about it. The difference here is he was not an eyewitness to this event, correct?
Correct.
She was.
That's unclear. There's no evidence of that.
But she was in the house.
She was in the house when she called him. There's no evidence that she, in this record, that for the juror, that she was in the house when it happened, or when she got to the house, or what she saw, anything. Or she saw anything. There's no evidence that she saw anything in this record. She simply, and I don't dispute this part, called him, and he said, "What's going on? There's been a flood." There's no evidence that she saw it. Maybe Lucille, the mother who had passed away, said, "Oh, I had a flood that's been cleaned up." For this jury to speculate on when she got there, whether or not she called from the house, anything, is absolutely inappropriate.
What evidence do we have in this record as to where she came by that knowledge about the flood?
Nothing. What we have is, in the record, I think in my opening, I said she was down for Thanksgiving. That's all I said. They said I was going to call her. I never said that. And I made it clear to the trial court judge, I don't believe I said that. I didn't have a record at that point, but I don't think I said that. And in the record, it's clear, I never said that in opening that we were going to call her. It wouldn't have made a difference. That's not an exception to this rule.
What about this, though? We do know your client was not home, did not witness the event, correct? We know that for a fact.
Correct.
So is that a feature of this?
It's not a feature of this. It doesn't give them an out. It doesn't give them an opportunity to go around obliquely, as they said. See, they knew what they were doing was inappropriate. Because he said, well, maybe we can do it indirectly or obliquely. They knew it. And my client wasn't there when it happened. But State Farm came right after the loss and investigated the claim and found there was accidental direct physical loss by water at the home and assigned that date of loss. Now, it looks like, and I put it in my brief, both parties were confused about what was the date of report and what was the date of loss. That happens. It was fair game for them to say, well, wait a minute, he said now it's got to be the week before because 22nd was Thanksgiving. Seemed like an odd day for Thanksgiving, but it was. And nobody picked up on that. Fair game to attack them on that. You weren't there, now you've changed the date. But to ask for an inference, and then to specifically say that the sister, and I've got it mapped out, these are 2 and 3 lines apart in their closing statement. Well, who was there? Well, the easiest thing in the world for them to do is call them in to corroborate. Completely violates that rule.
Let's talk about the rule real quick against adverse inferences and comments upon the absence of a witness.
Yes, sir.
Am I correct in understanding that the genesis of that rule, at least so far as the Florida Supreme Court is concerned, was in a series of criminal cases? Right?
That's a great question. It started with a criminal case, but if you look at my brief and theirs, we've cited 5 criminal cases that adhere to that rule and 6 civil cases.
Sure.
So
my
applies
question was
equally.
going to be, I didn't see a case that came out of our district, the 5th district. I saw some case law of the 2nd and the 3rd district. So are you aware of a case in which our district, the 5th,
Not
has
saying-
applied this rule in the context of a civil
I
case?
can't say one way or the other as we stand here right now in that issue. It'd be surprising to me that the 5th has never dealt with this issue, but I don't recall, maybe when I
If
said.
we have, let's just assume for the sake of this question that we haven't. Then what you would be asking us to do is to take the rule that has been enunciated by the Florida Supreme Court only in the criminal context, where some of our sister courts have extended that rule to the civil context. You're asking us to do the same.
Absolutely.
What's your best pitch for why we should do that?
Because it calls on the jury to speculate as to what the witness would have said when they're equally available to both parties. And calls on me to get up then and rebuttal on that and say, well, hold on a minute. The sister, how do I respond to that? Ethically, how can I respond to that? And now inject things that are not in evidence as to what she may or may not have said.
So what's the substantive law at play? You mentioned ethically. Are we, expounding a rule of professional conduct? Are we expounding some sort of due process principle? The criminal cases that dealt with this rule talk about a due process concern over confusing the jury, that the defendant somehow bears the burden of proof in proving his innocence, which is not true. Right? The state bears the burden of proof in a criminal case beyond a reasonable doubt that the defendant committed a crime. Here, we deal in a context where your client bears the burden to prove his claim. Right? So that concern, at least, I think is not present under these circumstances. So what is the substantive law from which this rule arises? Is it a due process clause? Is it a rule of professional conduct? What is the actual, foundational law that we are construing in order to, mark the boundaries of this rule?
If we look at Martinez versus State, an inference adverse to a party based on the party's failure to call a witness is permissible when it is shown that the witness is peculiarly within the party's power to produce.
Sure, that's the content of the rule. But my question is, where does it come from?
Yeah, there's an and the testimony of the witness would elucidate the transaction. There is no evidence in that record that this witness could elucidate.
Sure, that's my question. My question goes to the foundation. Like, where does this rule come from? Does it spring from due process, or does it spring from the rule of professional conduct? Because it can't just come out of thin air, right? There's some actual substantive law upon which this rule is based. And in the civil context, my question to you is, is it a due process concern, or are there cases that talk about a rule of professional conduct? What in your view, extends this rule to the civil context?
It's forcing the parties, or asking the jury to speculate on what that witness would have said and going outside the record. And that there's an ethical constraint on me from asking the jury to do that. As to due process, and I'm not talking about constitutional due process, but there is fundamental fairness that if somebody's equally available to the party, it's clear from this record that both parties thought there was maybe something good in that deposition and something bad. To allow one of the parties to then say, well, this is all you had to do, they had to call people who were there and ask that, they're asking the jury to speculate on exactly what that person would have said when there's no basis for that speculation. And in addition, calling for that negative inference. There is not one case they're going to bring up that says that there is a distinction between, in the rule, between criminal and civil cases. Not one. It may have started that way, and it may come up more starkly because of that burden of proof issue, but the cases we cite make it clear. The only time that would happen is if we assume some burden of proof that we don't have. We assume it, and the witness is in our control. Well, the sister's clearly not in control, and both sides are equally able to call or to read that position. So it violates every single principle they have. They don't have one case that says it should be distinguished between the two.
And Mr. Nation, you're about 2 minutes into your rebuttal time.
Okay. And we're going to do the second argument just totally separate?
Yes.
Okay, thank you. Thank you.
Thank you.
May it please the court. Brett Albrecht of Kubicki Draper for the defendant, State Farm. The jury's verdict and the defense judgment should be affirmed. What plaintiff is trying to do here is to broadly lump all of the defense closing arguments regarding plaintiff's lack of credibility into what was a very narrow pre-closing motion in limine and a very specific ruling. So that is why most of plaintiff's arguments in this appeal are not preserved. And those are the 2 points that I want to discuss briefly. First of all, why plaintiff's arguments are not preserved.
Let's move past preservation unless one of my very able colleagues may have a question about that. Let's get to the ethical issue. Mr. Nation just brought up. Like many here, I've tried a lot of cases as a judge and a lawyer. What would Mr. Nation say in rebuttal in response to the State Farm argument as to why these witnesses were not called? Doesn't it force him outside of the record and potentially compromise his ethics, as he said? For example, and I know it's not our case, 3 eyewitnesses to an accident. 2 are called. It's the plaintiff's burden of proof in this auto accident to prove whether, in fact, the other side was guilty of negligence. And the 3rd witness is not called, so the defense attorney gets up and said, well, they didn't call the 3rd witness. That must mean they were going to say something adverse to their position. What does that attorney do in rebuttal? Aren't they forced to say, I didn't call that witness because the defense attorney had already spent too much time and they were boring the jury. I didn't want to burden the jury with more things. Aren't you forcing the lawyer outside the record in those situations?
Your Honor, your question brings up a very good point, and that is it is a very fine line between what is an adverse inference argument and what is a fair comment on evidence. And Your Honor's example, there were 3 witnesses and only one was not called. That's not what we have in this case. In this case, it is not a failure to call a certain witness. This is plaintiff's failure to call any eyewitnesses
I guess my
to the
point,
incident.
and I didn't ask a great question for which I apologize, but what would you have him to say here in rebuttal? How would he respond to that unless he goes outside the record? Well, the reason I didn't call the sister was because. Well, isn't that the very ethical dilemma he just referenced? And doesn't the argument by State Farm in this case foist upon the other side an ethical dilemma?
It doesn't, Your Honor, because this was a strategy decision by plaintiff. Plaintiff, we don't even have to get to rebuttal closing arguments.
And thank you for saying that. If it was a strategy decision, that's the very essence of the ethical burden, is it not?
Your Honor, I think this is more of an issue of what is a fair comment on the evidence. It's not an ethical issue. There's wide latitude in closing arguments. You'd be getting into an ethical issue if defense counsel was bringing up things totally outside the record, things that were not in evidence. That is not what happened here. There was a very specific motion in limine. What did plaintiff ask the court to keep out? Don't let him say I didn't call my sister.
How does, help me understand, how does Mr. Nation respond to the comment by State Farm's attorney? What does he say in response to that?
Well, Your Honor, I mean, he can say a number of things. He can explain the date of loss discrepancy. He can explain that his sister is in New York. He has the same latitude.
Is that in the record, though? Was it the fact that she was in New York in the record?
Your Honor, I don't recall offhand. But again, I think...
But doesn't it, again, force him into saying something like, I didn't feel like we needed it because, and in that trial strategy, which is not in front of the jury and they haven't heard that evidence, aren't you imposing that by what you would have us to say as far as a role? Aren't you potentially creating situations where you're bringing things outside the courtroom, things that the jury has not heard until closing argument, in order to rebut things that are injected during closing argument?
Your Honor, the best way to answer your question, I think, is this is not that. Again, you have to take a step back. What is it that plaintiff specifically asked to be kept out? What was the specific ruling? Plaintiff's motion was not fully denied. The court specifically limited the defense to more generally commenting that there were other people there that day and the jury didn't hear from them. That falls on the fine line between adverse inference and fair comment. That falls on the side of fair comment. And before we even get to closing arguments, you have to look at, well, was there anything else that plaintiff could have done? I mean, he could have asked to reopen the evidence at the close of the case. He could have offered her deposition at the close of the case. He could have offered the deposition of Lucille Brosnan. There are other things that he could have done. What he did is decide to rely solely on his own testimony when he wasn't even there at the time of this loss. So it was perfectly permissible for the defense to comment in closing on plaintiff's lack of evidence. That's what this was. This was the defense commenting on plaintiff's lack of evidence.
Were those words used, lack of evidence?
Your Honor, that was the gist. And in fact...
So they were not used, correct?
Well, Your Honor, that was the point of the argument.
I think the words used in the closing were corroborate.
Corroborate, that's correct. And again, this is a fine line here. The fact that it's a fine line between what's fair comment on the evidence and what is an adverse inference argument, that confirms that there was no abuse of discretion by the trial court in its ruling limiting the scope of the permissible defense comments in this case. Because it was a fine line, again, the fine line here was not crossed. This was not an adverse inference argument. It was not about the defense commenting on plaintiff's failure to call a certain witness. It was plaintiff's failure to call any witness who was present on that date. It was a fair comment on the evidence. Plaintiff bolstered his own testimony by saying others were there on the date of loss. Plaintiff is the one who said that his sister was there that day, that his sister is the one who called him while he was at work. It was plaintiff who testified that their mother, Mrs. Brosnan, was there at the time, and even plaintiff's nephew was there. Plaintiff then failed to offer any eyewitness testimony, but at all. He came home after work. So for those types of reasons, it is very fact specific, and that's why we're saying that this falls along the lines of being a fair comment on the evidence and not an adverse inference.
So backing away from the facts in this case for a moment, I kind of want to delve into the doctrinal framework that I was doing with the friend on the other side. And as I understand your argument, I don't hear you contesting that this rule against adverse inferences and comments on witnesses' absence, that rule applies in civil cases. It sounds like you're accepting that premise. I'm curious to hear from you, what is your understanding of the actual substantive law from which that rule springs? We've already gone over the content of the rule and its contours, but I'm interested in the civil context specifically. What is the substantive law that this rule is operationalizing? Is it a due process requirement? Is it instead, an ethics concern, a rule of professional conduct sort of concern? Is it a mishmash of the two? What do you understand to be the substantive law that gives effect to this rule?
So it's rooted in the best evidence rule. It is rooted in the spoliation rule. It has its origins, as we've all discussed here, in the criminal context where the state always has the burden of proof. The defendant does not have to call any witnesses to refute an element of the crime. But, so the state can't comment on a defendant's Fifth Amendment right to remain silent, or the fact that the defendant did not call any witnesses. So, I don't know that it has a perfect application in the civil context. Because that is what plaintiff is arguing here, we're trying to say, well, for the sake of argument, if it does apply in civil cases, which other DCAs have applied it, so for the sake of argument, if it does apply in civil cases, well, first, you have to apply it to the civil case. The burden of proof prong, the two elements of the Jackson test, it's not really a perfect fit in the civil context, because in the civil context, it's the plaintiff who always has the burden of proof on their case. So, we believe that if it were to be applied to the civil context, in this case, it would be met because the plaintiff did have the burden to prove an accidental direct physical loss on, the date in question or during the policy period. And then the second prong is the special relationship. So, here we're arguing that it's not an adverse inference argument, but even if it is, that it would meet those two prongs because we're talking about plaintiff's sister. Even if the deposition could have been read by either side. The fact remains that the availability or unavailability turns principally on the relationship. And here, it was his sister. Plaintiff could have moved to reopen his case. He could have offered his sister's testimony by deposition or Zoom. He could have offered his mother's deposition. Instead, he offered only his own testimony. At a minimum, this shows why the defense closing arguments falls on the side of being a fair comment on the evidence and not an adverse inference. And that is why there's no abuse of discretion. This is not a situation where no reasonable trial judge could have issued the ruling trying to find a balance between what happened during plaintiff's cross-examination and, allowing fair comment on the evidence, but not stepping over into what might be an adverse inference. Even if the defense comments were improper, even if the narrow in limine ruling was an abuse of discretion, even if no reasonable judge could have allowed the arguments, even if this case still does not meet the high standard for requiring a new trial for allegedly improper closing arguments, even if it's preserved, even if it's improper, even if it was an abuse of discretion to allow it, the comments were not so highly prejudicial and inflammatory that it vitiated the fairness of the trial. And I just, want to make clear, there was a specific motion in limine. There was a specific ruling. And then you have to look at what defense comments were within the scope of the motion and the ruling because everything else was fair game.
Is that a feature here, as you know, State Farm moved not to have comment on people not being there. And then ends up commenting on people not being there. Is that a feature of all this for us?
And Your Honor, again, I have to go back to that fine line. And if you look at some of the cases, I'm not trying to avoid your question. I'm just saying it's not a yes or no answer. It's very fact specific. And that general rule here, the trial court tried to achieve a balance.
Did I get that correct? I mean, State Farm did move in limine.
That's correct. It was the general, if we, as one example, State Farm had listed 2 experts, but only calls 1. So that was an example. But again, here you don't have a plaintiff who failed to call a specific witness. This was plaintiff decided to rely only on his testimony. When in his testimony, he said there were 3 people there that day, and he didn't call any of them. So if we look at the cases, that delve into this issue on what falls on the side of fine line and fair comment. State Farm's position is that this falls on the line, along the lines of being a fair comment on the evidence.
But counsel, didn't this comment go truly to the heart of what the issue was? We're talking about question 1 on the verdict form, whether or not the loss occurred during the policy period. So there's only one witness to that they put on. And just so we're clear, there was a loss in 2016 that was claimed and then canceled, but it was the same as right?
Correct.
So that's why this all really matters, because there's some other facts that sort of go to this same issue, were there not? So saying that there's now no witness, that goes to the heart of that issue, does it not?
Well, it is important to the case, but I think it's important to look at specifically what the comments are. The only comments that fall within the specific motion or ruling are on pages 3872 to 3873 of the record, on 3877. And Your Honor, I see I have 10 seconds left, so I will refer you to those pages.
You can
Proceed. So
please, go ahead.
the only comments that we believe were within the scope of the motion and the ruling on page 3872, this is summarizing plaintiff's cross-examination. Defense counsel is recapping, saying, he asked Mr. Brosnan, where were you? I got a call. From who? From my sister. What did she say? There was a flood. Where were you? At work. That's the first reference, arguably within the scope of the motion or ruling. The second one, 3873. Again, recapping plaintiff's own testimony. You remember there were people at his house that day. Why? For Thanksgiving. Now, the easiest thing in the world right now, if Mr. Brosnan wants to fix that date, because now he said, well, maybe it was the Thursday before Thanksgiving, the easiest thing in the world right now would be to bring people in to corroborate that. That would be the easiest thing in the world to do. The last reference on page 3877, it wasn't on Thanksgiving, wasn't the week before. No one came in to corroborate it. That would have been easy to do. Those were the only comments within the long closing arguments within the scope of the ruling, we believe that those comments were isolated. They don't meet the high standard for a new trial, and the trial court did not abuse its discretion. So for all of those reasons, and those in our brief, we are asking the court to affirm the jury's verdict and defense judgment. Thank you, Your Honor.
Thank you.
I'll be quick and I will try to run through the questions that were asked. This was a close case. This was a case where the State Farm found water damage from the plumbing system. Then the issue becomes question 1 of the verdict form. Their whole closing started with, you don't have to get into the exclusions. You don't have to get into questions 2 and 3. The only issue is question 1. That's it. We put on a witness about that. And we cross-examined their field adjuster on that very issue with their coverage letter. And then the closing becomes on that issue. They're the beneficiary of this, what I'll say is error. What we're claiming is error. They have not proven that it's harmless at all. It went to the very heart of this case. And think of the havoc if this rule only applies in civil cases. Think of it. Now, they filed this motion. You're correct, Judge. They filed a motion the week before trial that we not be allowed to comment on them not calling a witness. Am I now, at least in the Fed, able to say, well, they've listed 3 engineers, no one called 1. You can think about what they would have said. And the judge said, the first thing you ask is, doesn't it force me to go outside the record? 100%, absolutely. I couldn't say to the jury, look, she's in New York. There's nothing in the record about that. She's in New York. We've taken the deposition. By the way, there's a rule that says either side can read her deposition, and they chose not to. Now, what do you take from that? There's a negative inference you can draw from them not reading her deposition. I'm hamstrung completely on that issue, on the very focus of the heart of this case. As to strategy, both sides decided not to read that deposition. They're the ones that asked to violate the rule and talk about us not calling her. Whether we had the availability to call her and then calling them to speculate on what she would have said. there's no requirement that we reopen the case to, okay, fine, forced our hand, we got to read the deposition that both sides decided they didn't want to read. There's a rule, it needs to be applied. My client didn't bolster his testimony. The only evidence in this record is he was asked a question by the defense, who was at the house. No details about it all, the sister. That's all that was there. And obviously, we know the mother had passed away. And it doesn't change the rule if, well, they could have had the mother's depo too. And they didn't argue that anyway in closing. And they argued in their papers and today, we didn't ask the jury to draw a negative inference. Well, search the record, that's exactly what they did. Inference, inference, inference. And now let me draw the inference for you. And as to special relationship, no way a sister in New York's a special relationship that focuses on the ability to control, both from a physical standpoint and a geographic standpoint. And both sides had the ability to read her depo. Obviously, what I'm hearing in the end of their argument was really a Murphy analysis, and I think preservation is the old West and it's been preserved. So that would be it. Are there any questions? No. Thank you. Appreciate it.
Thank you. All right, so we're going to take sort of part 2 now of this case, as I mentioned, and I said I was going to give you a bit of a roadmap. I forgot to let you know that we're going to take a 10-minute break after this argument before our final argument today. So just so you are aware in case you need to step out for a moment. All right, so with that, if we are ready, we will go ahead and take case number 23-1055, which is State Farm Florida Insurance Company versus Glenn Brosnan and Lucille Brosnan. I hope I'm pronouncing that correctly. I apologize for that.
May it please the court. The order denying defendant's motion for attorney's fees and costs under the defense proposal for settlement should be reversed. First of all, and there were 2 broad main points that we want to go over today. First, the proposal for settlement was not invalid just for having a release. That's the retroactivity argument that we're arguing about whether or not it's a retroactivity argument. That's number 1. And number 2, the terms of the proposal for settlement and release were valid, they weren't ambiguous or overbroad. First, the retroactivity argument. Plaintiff claims that State Farm's proposal for settlement was invalid just because it had a release. He claims this is not a retroactivity issue because the statute, section 768.79, allegedly never allowed a proposal for settlement, or PFS, to include non-monetary terms like a release. But plaintiff's entire argument rests on the Florida Supreme Court's decision amending Rule 1.442 to specifically disallow non-monetary terms like a release. Without that amendment, without the in-rate rules amendment decision, plaintiff would not have an argument because previously the Florida Supreme Court in the Nichols case had held that a broad general release is a valid condition and can be a condition of a proposal for settlement so long as it's sufficiently specific. So this is an issue of retroactivity. Whatever plaintiff wants to call it, can't change that. State Farm acknowledges that the rule amendment effective July 1st of 2022 was intended to bring the rule more into alignment with the statute. But it still was a dramatic shift in the law because for the prior decade or so, Florida courts had unanimously held that a proposal for settlement could be validly conditioned on a broad general release. And in this case, the defense proposal, it was served, it expired, and final judgment was entered before this rule amendment took effect. So that means to hold the defense proposal invalid as a basis for awarding attorney's fees just because it had a release, that would require a retroactive application of the rule amendment precluding releases. But retroactive application...
Let's assume for a moment it's prospective. and that's your argument, that it was valid at the time that the proposal was served. What about the argument that this language, this indemnification language, would arguably force Mr. Brosnan to indemnify State Farm against his mother's ongoing claims? How do you deal with that, given the verbiage in this hold harmless clause?
That's a good question, Your Honor. So plaintiff's challenge to the indemnity and hold harmless provision of the release attached to the proposal for settlement, the problem is it reads the language too narrowly. You have to read the whole proposal for settlement, the whole release, and the whole clause. And here, we agree the clause starts out very, very broadly, perhaps more broadly than it needed to, but then it gets very narrow and it says what it means. It leaves no doubt that third-party lien claims are met. The broad any and all list is expressly limited to, and here I'm quoting, it's expressly limited to those brought by any third party, more specifically, any liens. And then it goes on to list a number of different types of liens: mechanic liens, public adjuster liens, and claims by mortgage holders or lien holders. So the clause would not require what Mr. Brosnan, what plaintiff is suggesting to, if it was accepted, it would not require Mr. Brosnan to defend the continued lawsuit against State Farm by Mrs. Brosnan. No court would have applied it to mean that when it says that it means claims brought, but the broad claims listed.
What do you do, and I'm looking at the same language, it also says arising out of event or proceedings referenced herein. Same argument as to that language?
It is the same argument, Your Honor, and that specific part is not part of plaintiff's argument. His specific argument is that if this proposal were accepted, it would require Mr. Brosnan to defend State Farm, essentially, pay for State Farm's defense against the continued lawsuit by Mrs. Brosnan. There's no reasonable interpretation of this clause that would have accomplished that, even with the additional language that you just read.
Well, the language I just read, does that hurt or help your argument? I want to understand personally. Arising out of event or proceedings referenced herein, is that a focused statement that assists your argument that it's just limited to this case, or does that give some leeway to Mr. Nation's argument on behalf of his client, that this was invalid for the reason advanced in his briefing?
Your Honor, it doesn't change it one way or another. In all candor, that is another typographical error, one that was not raised by plaintiff. It should say proceedings on the word "or" there that you just read. It should be on. However, that doesn't change the fact that right before that we have defined the any and all scope to very narrowly mean those brought by any third party, more specifically any liens. And it's that wording that we contend.
What do we do with the typographical error?
Well, Your Honor, it depends on the nature of the typographical error.
And I know the cases are both ways. Sometimes they're set aside. Everyone knows what was meant, and then other times they matter.
Right. So, for example, Your Honor, the typographical error there, which wasn't raised by plaintiff, and we're talking more broadly about the lien provision and why we believe it's sufficiently narrowed by the part we quoted. Typographical errors like that, we would argue, do not reasonably affect the offeree's decision whether or not to accept, as evidenced by the fact that it's not among the arguments that plaintiff specifically raised challenging the proposal for settlement.
I understand you're saying these specific words were not raised, but in a general sense, the argument was this is just too broad. And I guess this judge's point is that's some broad language, given the oral.
It is broad. I would also point out that even the word proceedings, and I guess this kind of brings us into the next point, which was plaintiff's argument that extrinsic claims were implicated by the broad language, such as that from the release. But whether it's the indemnification of hold harmless clause, whether it's the more general what the heck is release, like any and all, everything under the sun, that broad language is then very narrowly tailored to this specific. And before I jump ahead of myself, you mentioned the word proceedings. The word proceedings is defined early on in this release to mean the specific lawsuit and case number, the specific claim number, the specific property address, the specific insurance policy number, and even the specific civil remedy notice of insurer violations, which was filed before this proposal for settlement was served. So all of the broad language, whether it's the indemnity language or the more broad release language, it then is very narrowly tailored to any and all everything in this specific lawsuit, claim, policy number, date of loss, property address, even the CRN number. So that's why we believe that the proposal for settlement, although broad, is sufficiently narrowly tailored to these proceedings. So, and Your Honor, just moving on with the extrinsic claims arguments, I also want to point out, plaintiff is saying that we couldn't include a release that included bad faith.
I just want to ask about the whole release thing again. I understand the old cases, and I know free rule change said that you could append a release, which makes sense because those were exchanged, still are exchanged every day, correct?
Correct.
So that under the old rule was allowable. From State Farm's perspective, how broad can you get with these releases? Wouldn't there reach a point where the other side could go, I would never sign off on that? That's just too much. I mean, where is that line for us?
And Your Honor, the line is it, at least the distinction that I see in the case law as to which releases are invalid and which ones are valid, the distinction seems to be, is it narrowly tailored to this specific case, claim number, policy number, property address, date of loss, etc. Because you can even, there's even, and I don't recall offhand exactly which case says this, but standard release language, you can release everything from the beginning of the world until these presents. I mean, that's pretty broad language, but then if it's tailored, for example, in the American Integrity versus Branford case, which didn't have that wording, but did have very broad wording, it was then tailored to the specific case, claim number, policy number, etc. And we recognize that in some of those cases, maybe that wasn't the exact point the court was dealing with, but that is still the distinction that I see in the cases of where that dividing line falls, is if the broad language is then tailored and sufficiently narrowed, that it should fall on the line of upholding the proposal for settlement and the release. Your Honor, I see that I'm into my rebuttal time, and obviously for any arguments we don't get to here or in rebuttal, we will be relying on our briefs, but I'll reserve the remainder of my time. Thank you, Your Honor.
Hello again. I'm hopeful this argument is not necessary based on our first case. Having said that, in the statute allowing for the fees has never allowed for release. That's what our Supreme Court has said when they did their amendments on May 26, 2022, which was before this order was made. And they made it clear in that the statute doesn't allow for a release, no non-monetary terms. And then says specifically, the amendments are intended to align Rule 1.442 with the substantive elements of Florida's settlement proposal statute. The only source they have for fees is the statute, not the rule, the statute. And what the Supreme Court is telling us is clearly, this isn't allowed. It's aligning, it's not changing. And they go through, however,
So counsel, are you asking us effectively to declare that the prior version of Rule 1442 was void ab initio, at least with respect to its authorization of non-monetary terms?
I don't think I'd word it that way. If I'd be so bold if I was writing it, I'd simply quote the Supreme Court and say, this is what we're holding. We're following the Supreme Court's guidance on this particular issue. And then if we look.
But you do acknowledge that the prior version of 1442 authorized non-monetary terms.
The rule did, not the
Right,
statute.
the rule did, right. So, also, at the time that this offer was made to your client, the then effective version of the rule was the old version of the rule, which did authorize non-monetary terms, right?
Yes, absolutely, 100%. But if we look at the appendix to the decision in 2022, when they strike out what they struck out and add in what they've added in subsection C, and then just strike out the whole section on B, and they're saying we're aligning our rule. In other words, we all write stuff, and then maybe a year or two later, or whenever, we look at it and go, you know what, I got that wrong. And what the Supreme Court's saying is they did get it wrong.
Is it true that in the opinion amending the rule, the Florida Supreme Court never said anywhere that it intended its revisions to have retroactive effect?
When they said we're aligning it with the statute, I think that's exactly what they're saying.
But that same opinion gave an effective date of July 1, 2022, did it
It
not?
does. It absolutely does for the rule change. But what it's saying is we're aligning our mistaken rule. We're aligning it with the statute, which is the only substantive basis for fees in this case. They don't get fees under the rule. They get fees under the
Which
statute.
takes me back to my first question. Aren't you effectively asking us to declare void ab initio, meaning, a nullity from the beginning, right, when it was first, promulgated by the Florida Supreme Court, that it was, in contravention of statutory law, and therefore can't have any application insofar as it authorizes non-monetary terms?
I think that's the effect. I don't know that I want, again, word it that way, because I think it should be the rule itself doesn't grant fees. It simply is procedural. And the Supreme Court has recognized that the prior rule added this section about non-monetary terms, which is not bound by the statute. And in 2022, the Supreme Court corrected itself to bring that rule into alignment with the statute. I don't know how they get fees when the Supreme Court says the statute never allowed for these non-monetary terms.
But prior to 2022, the cases are legion that said you can have a release and that's okay, and they can include non-monetary terms as long as the particularity and other requirements are met, correct?
Okay.
And they didn't recede from those cases with the amendment, correct?
They didn't address that issue one way or the other. I don't know if they could recede from case law without parties involved in an administrative law amendment. But when they use that word alignment and bring it into alignment with the statute, I think that's they've chosen that word very specifically, recognizing that statute never allowed for that. All right? And it is too broad. It is too broad. It has third parties in it, in that release. It requires my client to lie and say that this was a negotiated, and both sides have written, I don't have the specific language. Let me see if I can pull it. That they've negotiated this, and it contributed to the drafting of the release. That's a flat out lie. It's a crime. And my client couldn't sign that. We did raise also that extrinsic grounds are included in that release. The bad faith claim, could not have been litigated in the underlying case, couldn't have been even brought in the underlying case, and yet they want extra contractual and statutory claims, which is clearly bad faith. They want those released with this release. While the 5th ECA in Blanchard has said, if a party accepts a valid or a proposal for settlement that is valid, it doesn't extinguish the bad faith case. So the law at the time that this was issued, and still today, is my client, if this had been properly drafted, could have accepted the proposal for settlement, accepted the recovery for the money, and then filed a suit for bad faith. Their defense is, yeah, that's right. That's why we wanted to extinguish the bad faith with the proposal and the release. Well, that took it outside of the statute clearly, and even further than the rule that was in play at that time. It allowed, in taking that right away from my client. And the fifth is the only case in the state, but it says that absolutely, when you accept a proposal for settlement, you can bring a bad faith case. After that, and we did raise, because they in their brief raised an issue that caused us to look a little bit closer at this issue, and that is that the proposal says that it releases all claims which could have been brought in this. Well, we did bring a claim for attorney's fees and costs in this. And so it extinguishes all claims, and then later it says this offer is, it doesn't say whether or not it includes fees or costs, which it has to do under the rule. It doesn't say that. But then says it's exclusive of fees and costs. I don't know what that means. I don't know if that means it's all claims and you don't get any fees and costs. Because this is exclusive. We're not offering you any fees and costs, and it excludes it, and you're waiving all claims. Or are they saying you can accept this proposal for settlement and come back and ask for attorney's fees and costs? And therefore, we didn't make that argument below. But if there is a valid reason to affirm, we're allowed to raise that argument now. It came up because they had raised some issues in their brief on that issue. As to the indemnification is clear. It doesn't define third parties, and it does say arising out of, which is as broad a language as you can have. Whether it's a typo or not, that's not valid. My client could not have accepted that without risking at least some court saying, you know, it says third parties. It says any claim that could have been brought arising out of it. Lucille, the mother, continued her case. You owe their attorney's fees and their costs and have to indemnify them for them. Which is why the Supreme Court has said, we're going to line this rule with the statute, get this out of it, so we're not up here all the time arguing these things throughout the state.
So
Yes, sir.
just going back to the Supreme Court's rulemaking in which it changed the rule text, what do you understand to be the significance of the court providing an effective date for the rule change?
They have to give an effective date. And that is the date that that rule comes into effect. That's all that means. What they're saying is, that's the rule change. We can't ignore the fact the statute, which is the only basis for the fees, is never changed. We're saying, I think what they're saying, and I don't want to put words in their mouth, but my impression when this came out is, look, we got the rule a little wrong. We're fixing the rule. Here's the effective date of that rule. The statute never allowed for this. Nobody's disputed that. Because the statute and the rule are at variance. Now the statute and the rule are consistent. And they can't get fees based on the statute or the rule. That's just how it's done. And the statute prevents them from getting fees. Thank you. I'll check. That's all I have. Thank you.
Thank you.
May it please the court. The first thing I want to address is the plaintiff's complaint in this case specifically asked for all foreseeable consequential damages. So in addition to that, and the civil remedy notice having been served and expired before this proposal for settlement was served, the proposal for settlement or release had to include bad faith. Otherwise, plaintiff could have accepted the offer, taken the money, and then immediately sued State Farm for bad faith, which wouldn't have resolved the case or the claim or anything else. The litigation would have continued. We don't have to guess what the indemnity hold harmless clause meant by third party. Here it said what it meant. It said any third party, more specifically any liens. So the clause, although broad, ended narrowly, and third party was defined as anyone with a potential lien claim. Plaintiff's arguments regarding the attorney's fees and cost paragraph were not raised in the trial court. Plaintiff has to give, has to raise the argument below in order to argue it as a basis for affirmance in the appeal. And those paragraphs were not challenged below. I also want to point out, as a practical matter, that it shows those paragraphs were ambiguous when plaintiff did not think to raise them until for the first time in this appeal, in seeking affirmance. Your Honor, I believe that plaintiff's arguments challenging the broad release, which is narrowly tailored to this case, claim-specific policy and date of loss, it falls on the line of being nitpicking, and the release and proposal in this case are more similar to the cases where broad general releases have been upheld. So for that reason and all of the reasons in our briefs, we are asking the court to reverse the order denying State Farm's motion for attorney's fees. Thank you, Your Honor.
Thank you both. At this point, we're going to take a 10-minute break called a recess, and we will come back and hear our final case. And I hope that our lawyers in these cases can stick around for our question and answer period afterwards if you're available. Thank you.
All rise.